By now, you know that a conservative-leaning Supreme Court has declared the unconstitutionality of affirmative action practices within higher education. Justice Thomas concurred with the opinion and felt so strongly about it that not only did he write a separate concurring opinion, but in a departure from usual protocol, he actually read it directly from the bench. And many of you pointed out how odd that is, considering that Justice Thomas is a Supreme Court justice today, also because he took advantage of programs like affirmative action. I'm sure you know that he entered Yale because of affirmative action, and he was also accepted before Yale to Holy Cross College because he was actively recruited by a Jesuit who would then become the president of the school when he recruited him and 19 other indigent Black Americans to join a school that was almost entirely white. Now, there's no doubt in my mind that within the halls of Yale and Holy Cross, Justice Thomas proved his worth by just working very, very hard, so much so that at Yale, he graduated in the top 2% of his graduating class. But today I want to give you a slightly different perspective of his concurring opinion because I believe it is unfortunately not a judicial opinion. It isn't rooted in the law, but it is a political opinion. It is rooted in personal convenience. I'll walk you through the reasons why I think he exploited the 14th Amendment and basically exploited it to frame affirmative action as unconstitutional. Thomas was born in a small town in Georgia called Pinpoint and grew up a marginalized child. He was always bright, but to give you an example, he was known around town as ABC, America's Blackest Child. That's how prejudiced people were in the town where he grew up. He spent his life branded by the color of his skin, surrounded by prejudice, and trying to prove as much as he could what his personal worth was. He also felt that the fact that he entered Yale through affirmative action also meant that he now had to carry another set of shackles, which made it impossible, for example, for him to find a job. He felt that the presence of affirmative action in his experiences stigmatized his success and his capabilities. He talked about it in a 2007 book called My Grandfather's Son, where he said that his degree, and I quote him, bore the taint of racial prejudice. In the book, he wrote that after graduating, he could not find a job. He kept on getting rejected, even though he worked just as hard, in fact, harder than his white classmates, and proved to be better than 98% of them. And that feeling that he carried with him all of his life is underscored by a line in the book where he says that he soon found out that getting a Yale degree meant one thing for white people and another for Black. After all, after graduating, Clarence Thomas was still a Black person in America. But now he wasn't just a Black American. In the eyes of white hiring managers, he was now a Black privileged American. And we all know America will not tolerate privilege among minorities. But here's where I disagree with Justice Thomas's decision. Well, that sentiment can be valid, and we really should listen to Clarence Thomas as he recognizes firsthand how programs like affirmative action can be useless if they allow Black Americans to access education, but then brands them as unworthy of being hired. While that sentiment is valid, it still does not warrant throwing away the baby with the bathwater. The problem isn't a program that gives some Americans an opportunity they would otherwise unjustly be denied. The problem is how society reacts to a program like that. The problem isn't the unconstitutionality of a program like affirmative action, but the fact that when a program like that is offered, white Americans generally react in a manner that just goes against the basic fundamental principles of the Bill of Rights. Justice Thomas is the first to recognize that without programs like affirmative action that got him into Yale or the program that got him into Holy Cross, he probably would have had a much harder time amounting to much. And that's because racism in America is a real thing. It exists, and it prevents bright minds, like that of Clarence Thomas, from being educated. And yet he feels that his experience after he benefited from those programs make those programs just not worth it. But what Justice Thomas doesn't recognize is that that's not the fault of the program. It's the fault of American society that still remains racist even after you've proven yourself. Affirmative action could have been saved and reframed to truly help minorities who in America are still the victim of silent segregation and prejudice. But that's not what Thomas did. I believe he exploited the 14th Amendment to declare affirmative action as unconstitutional in order to get even with a personal burden he still carries, caused by a still prejudiced society. Your concurring opinion was based on personal and not constitutional considerations, and that, to me, is the greatest miscarriage of justice.